Okay, hello everybody. My name is Jeffrey Ross. I'm the rector here at St. Peter's Church in Lewes. This is the last of our Life Before Death series that we've done in partnership with Beebe Hospital. And today we are blessed to have Rebecca Doyle from a local law firm who will be talking to us about the legal ramifications of death and the advanced planning that's necessary for us to do in preparation or that inevitability that we will all face at some point or another. Everybody thinks death comes to somebody else, but it is important for those we love that we make and leave plans for them so that they understand what our wishes are and how we can be good stewards of things that we've been blessed in this life as we pass that on to the lives that are near and dear to us. So before Rebecca starts, I just want to ask you please to mute if you haven't already. And if you have a question that comes up while Rebecca's speaking, please put it into the chat and then we'll come back to it. That way you'll remember it. And Rebecca probably will get around to answering it in a minute or two anyway, but that way we can have it if we miss something. I'm sure she'll be glad to take a couple questions at the end. So without further ado, it is my honor to present to you Rebecca Doyle. Rebecca, thank you for joining us today.
My pleasure. Thank you. Again, my name is Rebecca Doyle. I'm a local attorney at Baird, Mandalas, Brockstedt. And with my practice, I practice with Kevin Baird and with Barbara. That's the other estate planning and state administration and trust attorneys in our office. We are statewide. So we do each have a different county that we work in. And Kevin Baird is our managing partner. He goes throughout all of the counties. So I'm mainly in Sussex County. And 90% of the time, one day a week, I go to Dover and help clients in Dover. But other than that, the other 4 days a week, I'm in our Lewes office. With that, I've been asked today to talk about estate planning and legal ramifications and why it's so important to have documents. So there are 3 documents that everybody needs to have as part of their estate plan. And 2 of those documents where I saw on the outline were previously addressed. The first document you guys discussed in week 1, which was a healthcare directive. It's also called a living will. And with that document says who can make your healthcare decisions in the event that you're not able to make those decisions for yourself. So if you're in the hospital and a doctor determines that you're not competent or conscious, maybe you're in a car accident and you're in a coma, or maybe you have old age dementia or any other combination thereof. If you're in that state, you need to be able to say who you'd want to make your decisions for you. That's highly important because in the document, sometimes not everybody wants the person that you might think. Maybe for me, maybe it's my spouse, and then it's my sister who's a nurse. I don't want my dad to make those decisions because I think that would be too difficult for him. For some of my clients, they want, maybe it's a second marriage and they say, I want, my 2 adult children to make those decisions, and maybe they make those decisions together, or maybe it's a brother. So everybody has a array of people that they trust to make these decisions. And the most important thing for that is to pick somebody who can carry out your wishes, because that's the most important part of this. Okay. So in our document, we say who can make your healthcare decisions. After that, the second part is a HIPAA release. So that way the doctors can disclose your healthcare decisions to your agent so they can make an informed decision, very broad disclosure. And then the third part's what we refer to as a living will. In that, you can state in Delaware if you're in 2 of the limited circumstances. The first is that you have a terminal condition and death is imminent. Okay, this isn't that you have cancer and you're in a car accident. In that case, the doctors, if they believe that there's a chance of recovery, that doesn't even apply, that living will piece. At that point, if you're not competent to make your decisions, your agent would make those decisions. But if the doctors determine that the death was imminent and a matter of days or weeks, and there was no chance of recovery, then whatever you put in that document is going to govern. So if you said, I don't want any treatment, or if you say, I do want treatment, or I want very specific treatment, that's what they will give you, regardless of what your agent says. So if my husband's my agent, just because he's my spouse, he can't override my wishes. So it's very important that we take time to think about and document what we want so our doctors can carry out our wishes. So the first condition I just described, and the second is if you're in a persistent vegetable state or coma, okay, for at least 4 weeks in Delaware. So during the first 4 weeks, they will do whatever they can at your agent's discretion to carry out your wishes and to keep you going. After 4 weeks, if you said no treatment, they will disconnect treatment at that point in time. So very important document, because we have the right to make our end of life decisions with regard to that document, and to name who we want to make those decisions if we can't. So that's a very important document that everybody needs to have. Okay. One question that I often get is, what about a DNR? I've had many clients tell me, that they've heard the stories of somebody who stated that they did not want their life to be prolonged, but they called 911, and 911, the paramedics came out and they revived the person. And they said, well, that was against what they wanted. Well, that document only applies if your treating physician, 1, determines you're not competent, and 2, physicians determine that you're in that particular state where there is no chance of recovery. That is not a DNR. Only a doctor can write a DNR, okay? Do not resuscitate order. That's a doctor's order. So that is separate and completely outside of what that directive is. However, with that directive, you are indicating what particular treatment you would want or not want, okay? Does anybody have any questions about that particular document before I go on? Okay. So after that, the second document that everybody needs to have is a durable power of attorney. And I was looking to see if you guys had talked about that one. And it appears to me that that's probably a new document. Okay, so these are all legal documents. The durable power of attorney says who can make your financial and legal decisions if you're alive. You can make it effective either immediately when you sign it. So if I gave my spouse immediate power, which I do see from time to time, then he could do everything financially and legally that I could do. He could change my beneficiaries. He can sell my house. He could do anything financially and legally that I could do myself as my agent. Okay. He does have a fiduciary duty. So any actions he takes has to be in my best interest. But I don't really feel comfortable with my husband being able to sell my house and without me being aware of it. So I always recommend to clients that they make it effective only if and while they're incapacitated, because that's when this document is very important to have. If I have a treating physician determine that I'm incapacitated and I made my power of attorney effective only upon my incapacity, what happens is I sign the document while I'm competent. And then once the doctor certifies in writing that I lack the ability to make my own financial and legal decisions, with that doctor's note, my power of attorney springs into effect. And my husband, as my agent in that document, now has very broad authority to be able to do everything financially and legally for me that I could do myself. Okay. I once had a child say, can I file for divorce with this document for my mom? Probably. So, I mean, it is very all-inclusive as long as you give a broad power to your agent, which I generally recommend. So like I said, this is a very important document. If you're not competent, you need somebody to be able to make those financial and legal decisions for you. Sometimes when people are young, they don't think about, what if I was driving on Route 1 today and I got in a car accident and I was in a coma for 6 weeks? Who's going to pay my bills? If I then come out of that condition, what kind of state am I going to be in if nobody could do anything for me? Okay. So everybody needs to have one, because nobody ever knows when it's their time or what conditions could arise. But also with that document, you get to name who you trust to do that. If you don't have that document in place, then the court's always going to be available to name a healthcare agent for you or a guardian, okay? But that process is not something we want to rely on. Sometimes I have spouses and they say, well, I have a joint bank account with my spouse, so do I really need this document? Absolutely. Because if you have old age dementia or you're in a coma and you can't do things for yourself, your spouse can't sell your house. They can't help you with any government benefits that you might be entitled to. They can't change your beneficiaries if necessary. They can't do anything besides what you're a joint on that account for. So this document is very important because you want somebody that if you need them to be able to take the action, that they can actually step into your shoes, act on your behalf, and do everything financially and legally. Like I was saying, if you don't have this document, then what's going to happen is we're going to have to petition the court for them to become your guardian. I've had husbands and I've had wives and I've had kids have to petition for guardianship of their loved ones so that they can actually help them and make their financial and legal decisions for them because they lack the ability to do it. What that process entails is months in the Court of Chancery and thousands of dollars because somebody's appointed, an attorney's appointed to represent the person with the alleged disability, and somebody is also generally recommending the family member who's trying to petition for the guardianship. Okay, so a very simple document where you sign when you're competent can avoid all of that. The other thing is when you have a power of attorney, although your agent should keep notes and records of everything that they do on your behalf in case they need to present that, and if another loved one were to challenge it, they don't have any reporting requirements to the court in general. It's a private transaction where they can show this document to the institution and do whatever they need to do on your behalf. If you don't have that, then the Court of Chancery, they will require a bond be paid by everybody who's appointed as a guardian. So they're going to have to go file for a bond. And then, and that's for the safety of the person with the alleged disability. And then also they have to do annual reportings of medical to show that there's a continuing disability. And they also have to show every expense that they spend on your behalf. So if you go get a haircut, or if they take $20 out of the bank, or they pay your mortgage, they have to have records of all of that. The court will set a budget of how much they can spend on your behalf. And if they need to go over that in a particular month for a particular reason, they have to go back to court and ask for permission. If they need to sell your house, they need to ask for permission. If they need to do Medicaid planning or trust planning, they have to go back to the court and ask for permission. So it's an ongoing relationship because the court is the ultimate fiduciary for that person and is overlooking to make sure that that person, their best interest is being adhered to and that they're being taken care of, and then they're not being exploited by a guardian. Okay, so although there's a very good purpose for the reporting requirements, it's very burdensome upon the family member who's trying to help. Often these family members are trying to keep their loved ones in their home and trying to bring in services and food and care so they can keep the loved one in there and where you want to be, which is your home. But then they have this other, financial piece on top of it with the reporting requirement. So a durable power of attorney allows us to avoid having to go through the guardianship proceeding, and it allows whoever you trust to be able to make all of your financial and legal decisions when you determine it becomes effective. Any questions on that one before I continue? Okay, so then generally with both of those documents, we living in Sussex County, Delaware, we have a lot of people who move into the area. Maybe they've had documents prepared in other states. So often I'm asked, I do reviews all the time for people who have moved from another state, just wondering, is their document still valid? Do they need to update their documents, or is what they already have fine? So when I do this review, first of all, I always recommend that you have an attorney review, a estate planning attorney, review your prior documents to see what you have. And then as part of our review, what we're looking at is those documents are absolutely valid as long as they were properly signed in the state in which you executed them. But what we're looking at is we're looking to see what the powers are. So for a durable power of attorney in 2010, Delaware changed its law and we added powers that help. So that way, if we need to do Medicaid planning for the individual, that your agent has the right to do that. So just 2 weeks ago, I had a daughter come in who wanted to help get her mom qualified for Medicaid because her mom had spent through all of her funds. The daughter was self-paying for the mom's care until Medicaid kicked in, and she was borrowing money from a friend to help, to provide for her mom until Medicaid was available. But the mom, her assets in Delaware, when you want to qualify for Medicaid, there is a income requirement and there is an asset requirement. And for mom was over the income requirement, which means that the daughter needed to draft a Miller trust so that money could go through that trust, pay for mom's care, and then there's an amount that she can keep. So if the income's over that amount, then the daughter's, with the Miller trust, the daughter's able to still get mom to be qualified for Medicare. So I looked at the document that the mom had executed, her durable power of attorney, and the power that Delaware added in 2010 wasn't in there. It needs to say that she has the authority to be able to execute a trust. So that's one thing that the Delaware power of attorney has that not all states provide for, because it's something that Delaware just, in the last 11 years added for that very particular purpose. Not every state has a Miller trust, very few of them do. So very few durable power of attorneys actually have that as a provision in there. So that's an important provision that we are looking to make sure is in your document. Other than that, we generally give the agent the ability to change your beneficiaries, to change the way that land is held or how property is owned between husband and wife, or adding people or having the authority to add or remove people from the deed for your property and bank accounts. Other than that, there are other powers that are in there that are very specific for Delaware. So generally, if those powers are not in there, I will generally recommend that you update it. I always tell my clients, this isn't in there, I think you should update it for that. But if you don't want to, if that's not important to you, then what you have, as long as it's properly executed, is fine. Okay. The healthcare directive, Delaware, like I said, it's a valid form as long as it's properly executed. As long as it's properly executed, then then the document itself is fine. Most states provide for the same two classifications of when, for your advance directive, whether you'd want your life to be prolonged or not. Excuse me. But if you were in Beebe Hospital or another Delaware hospital, they may not be familiar with Arizona's, or they may not be familiar with Florida's healthcare directive. So for that reason, we generally do recommend that you update those when you are living in the state of Delaware, because we want all of these documents. We don't want anybody questioning whether there's the authority and having to have their legal department review it. We don't want anybody who has their hands tied because a power isn't specifically spelled out in your document. We're doing these documents to help the ones that we love help us. So we need to make sure that they're very easy and efficient to use in the event that they need to be used. Okay. So then the third document that you need as part of your estate plan is either a will or a trust. So with a will, so I'll back up for a moment. So property, when somebody passes away, property passes three ways. The first way that property passes is in this order, by joint ownership. So if I own my house and my car and my bank account all joint with my spouse or my daughter or my son or my best friend, when I pass away, whoever's the joint owner on that account, that asset becomes solely theirs. My husband takes my death certificate to the bank. He shows it to the bank. They remove my name. It's as though, it was never my money. It was always just his. And now the money is solely owned by him. Okay, so any joint assets will go to the joint owner as long as it's jointly held. If it's not jointly held, then property, we'll look to see if there's a named beneficiary. If there's a named beneficiary on an account, insurance has these, annuities have them, all retirement plans, IRAs, 401ks, even bank accounts can have a beneficiary, but they call it a pay on death instead of beneficiary. If I have that set up on an account through my financial institution, then if I pass away, that asset goes directly to the named individuals. Some of these forms, you can check a box that says that you would want it to go to the kids of the person who you have named if they predeceased you. Okay, so here's an example. My life insurance policy, I have on there my husband. So I write my husband's name, I put all his identifying information, and there's a box I can check that if he predeceases me, I want it to go to his biological or adopted children. That's called per stirpes. Okay, Same if I'm a parent, if I left everything to my daughter, if I checked a box, it would go to my daughter's children if my daughter predeceased me, okay? If you don't have a box on there or you don't check that box, let's say you have 3 kids and one of your children predeceases you and you don't remember to update the document or you lack the ability to update that document and you pass away, that property is not going to go to the children of the deceased child. It would go to the surviving children of yours. That's called per capita. So that just says, okay, you had 3 children named as 3 people named as beneficiaries. 1 predeceased you. There's 2 living people. The 2 living people distribute the assets that are in that account equally. Okay. It's important because the majority of people that I meet, they don't understand that because most of the time these institutions do not take the time to explain to you what these terms mean or what the default is. And the default is that if you don't check that box or if there's no box to check, it's only going to living named people. And that's generally not what most people want. Most people say, if I have 3 kids and 1 predeceases me, of course I want my grandchildren of the deceased child to receive what that parent would have received. But if we're not filling out these documents correctly, just because we're not aware, then our intent is not going to be carried out. Okay. So both of those ways all take precedence over our will. So a lot of times people think that all of my assets, when I do a will, all of my assets are going to go according to the terms of my will. But in reality, very few assets, when you do your planning correctly and what I call holistically, are going to go into the terms of your will. When I meet with clients, the only assets that I want going into their will, the majority of clients, is their house, if they're not married, and their tangible property, their car, and the contents of their home. And that's because in Sussex County, we have all counties have it. It's called a probate fee. And it's not a tax. Delaware does not have an inheritance tax. It's a fee. So any assets that come through an estate, except for your house, if you're gifting your house to somebody, are going to be subject to that probate fee. Sussex County is 1.25%. Kent County is 1.75%. And Newcastle County is 2%. So it all depends on what county you live in at the time of your passing, which probate process we're going to go through, and what percentage your estate's going to be subject to that percent. So that's important. It's important that people understand all of this because generally our house is one of our largest assets and usually our retirement assets are another one, okay? If I have $1 million in retirement assets, I don't want that to come into my estate because I'm going to be paying Sussex County 1.25% of that. I don't want that. I want it to go to my kids, right? I worked hard for that money. I want it to go to my kids. So if my kids are adults and able to handle that money, they don't have any addiction issues, they don't have any spendthrift or creditor issues, we're not worried about pending divorces, then I can name them as a beneficiary if I feel as though they're able to handle the amount of money that I have saved on the day of my passing, okay? So I always say, if you pass tomorrow, are you okay with your children receiving this amount of money? If the answer is yes, then I always recommend that they have a will and that they have beneficiaries named on all of their financial accounts, okay? When you have a will, the probate process is 3 steps in Delaware. The first step is going to be, we have to petition to open the estate. So series of documents that whoever you name as your executor or whoever is the next in line to be your minister will come in and they will file to open your estate. 3 months later, they have to file what's called an inventory, where they report all of the assets that you own as of your date of death to the Register of Wills. And then the third document is going to be an accounting. So just like I said with the Register of Wills, if there's a guardian, your executor has to keep detailed records of any expenses that they spend out of your estate, because it's not their money. They have a fiduciary duty to take to do what's in your best interest and that fiduciary duty to the beneficiaries who you're leaving the money to. So they do have the authority to pay your bills, to pay your mortgage, to pay any last expenses and taxes. So they do a tax return if necessary. But then at the end, they have to have documentation of every bill that they spend. So we can see the bill, we can see the canceled check, we can see what account it came out of to make sure that every expense is a legitimate expense on behalf of your estate. Once we do that, that's what the accounting is for. We're reporting all of that to the Register of Wills. And then there's a series of ancillary documents that we file with that. Once if somebody has an attorney, their attorney, as long as the debts are under $100,000, the attorney will look at those. The attorney's job is, we might have a paralegal initially prepare that document, but I personally, as it's the attorney's job to do, I go through and I look at every statement, I look at every bill, I look and match it all up because I have to certify that I reviewed it and everything's in order before that estate can be closed. So that's how an estate's closed. In Delaware, an estate, even if somebody has really no assets to go through estate, but we needed to open it for a reason, in Delaware, we have an 8-month creditor claim period. So that means that an estate has to remain open for 8 months from date of death. So that way creditors can come forward and file a claim saying that you owe them money and that they want to be paid for that debt. Even if you have no creditors, we still have to wait the statutory period of time. So that means that the soonest time frame that your executor can petition to close your estate is 8 months and 1 day from your date of death. Okay. So oftentimes, I guess kind of brings up a question on who should I choose as an executor, right? During the probate process, because of the time period, often when there's family issues that arise, that's really where it comes up. I always tell my clients, it's a messy time in people's life when they lose somebody that they love, and then it gets really messy when there's money, right? Anytime there's assets, it can get really messy. So I always tell my executors to make sure that they're in constant communication with the beneficiaries as appropriate. Maybe it's not appropriate to call them every day or to send them a text every time you do anything, but it is appropriate to keep them in the loop that, hey, this is going to take about a year before we can finalize mom or dad's estate. And the reasons that's important is that they express what's going on throughout the process is because oftentimes people don't understand that it takes about a year for an estate to be resolved and to be closed before there's any distribution of funds. We recommend that our executors do not do a distribution of any funds until after the 8-month creditor claim period, because if there's an early distribution of funds and then there's a debt that comes in and the executor gave out the money, now the executor is responsible for paying that debt because they could try to get it back from the person they gave the early distribution to, but if somebody asks for an early distribution, it's probably gone. So with that, we recommend that they wait, but I also recommend that you pick somebody who is the appropriate person. Oftentimes I'll hear that people get, when they don't hear news of what's going on, I have a case right now. They're like, hey, this estate's been open for 3 years. We can't get sister to tell us anything. We can't get sister to do anything. Sister's living in the house. We're going to court. So now we have a family that's being divided over assets because the sister won't communicate what's going on. Maybe what she's doing is very reasonable, but whenever you're on the other side and you have no information, you start to think the worst. She must be out there spending all the money, right? So I always recommend that when it comes time to picking an executor, that one, you pick somebody that will actually carry out the duties. Being an executor is a labor of love, just like being an agent. Sometimes people get worried. Well, my one daughter is going to be offended if I pick my son over my daughter. Well, you have to pick who you think is going to be the right person for each of these jobs. Like I said earlier, my dad's not my agent because I don't think he could carry it out. My sister, who's a nurse, can. For my executor, you want somebody who's going to timely prepare these documents. If it's somebody that can't even pay their own bills, or loses every single piece of paperwork, or maybe they're not the right person for that job. Because with the Register of Wills, if they don't timely act, they can get in a lot of trouble financially, as well as with, having to get called to court to explain why they're not doing what they've told the court that they would do. So to protect the family harmony, as well as to carry out the job as being your executor, we need somebody who can help pull everybody together, right? I don't want the person who's going to divide the family. I don't want somebody who's going to say, I'm in charge, so I'm not telling you anything. I want the person that's going to be able to communicate and try to get people to agree if there's disagreements, to try to iron stuff out, but also that is organized and can file the paperwork and keep stuff in an organized fashion and carry out the job that I've asked them to do. I need somebody who's trustworthy, okay? I've seen estates where, unfortunately, executors, luckily they weren't mine, have stolen funds from the estate. And that's, you get in a lot of trouble for that. So, so you need to pick somebody who's trustworthy and that will do the job that you've asked, okay? I generally recommend that you have one executor. If you really want to, you can have two, but what's going to happen is one's going to end up doing all the work. And if they decide to take a commission, they both have to take the commission. If they decide to take a commission, it is taxable as income. So most of the time when people are going to inherit from you, they choose not to take the commission that they could otherwise take, because it's better to inherit it at no inheritance tax than to have to pay, income taxes on that money. So I would recommend that if you think you want to name two or more, that you think a lot about that. Are they going to be able to work well together? And this really goes for all three of your documents. Are they going to be able to work well together? Are they going to be able to work well together under stress? Are they going to be able to meet up together and make these decisions? Are they going to be able to communicate to all the parties? Okay, these are all things that you want to take into consideration. A lot of attorneys' offices will not represent any estates that have multiple executors, because generally it doesn't work out. Okay. I've done it where I've had three. And like I said, one did all the work and the other two wanted to know what all the work was, why there were fees and, what was going on and where was the money. So generally, I think it's best to have one. It makes it easier. Right now, I have two executors. One's in the state of Delaware and the other one, I think, is in California. So anytime that we have documents that have to be filed with the court, we email them to the son for him to sign, and then for him to send those to his sister in Delaware so she can sign them before we can actually get them back to file. So it's not as efficient as if I have a client in Delaware or California or wherever that can take them, print them out, sign them before a notary, send them back to me, and I can file it. So you just want to think about all of those different parts. For some people, having two people is necessary. Maybe it's a second marriage and you have a kid on each side, and you want to make sure both sides of both families are represented, especially if they're adults when you got together. So sometimes it is important to have that check and balance, or to just have the kids working together so everybody feels represented. So in those cases, you might decide, that they're just going to have to figure it out and they're just going to have to make it work. Okay. So that's kind of picking your executor, is you want to make sure you pick the right person. Under Delaware law, so oftentimes I have clients that come in and think that if they had a will, that they don't have to go through probate, okay? And that is a complete myth. There are three ways besides joint ownership, beneficiary, and then your estate that property can pass. So if you do not have a will, your loved ones will be going through the probate process and filing documents with the Register of Wills, and state law will say who receives your assets. It is not 100% your spouse. If you have any children with your spouse, or if you have any children from a prior relationship, or your parents are alive, your spouse only gets a portion of your estate, and your children or parents would get the other portion of your estate, okay? Most of the time, spouses want to make sure that their spouse is provided for first. So it's important that they have a will, because otherwise intestate law says where your assets go, okay? If you have a will, then your will says who your executor is, where your assets go, so who you want your money to go to, but they still have to go through the probate process. The other option is a revocable trust. A revocable trust is a probate avoidance tool only. A revocable trust, it reads just like a will, but it's longer because it has more terms. And it says who you want your assets to go to if you passed away. It says who your trustee would be. And then it allows us, while you're living, you're the trustee. When you pass away, you name your successor trustee, just like an executor. You say where your assets go after you pass away. While you're living, you're the primary beneficiary. So you're in control because you're the trustee, and you can control all of the assets because you're the primary beneficiary. So if you wanted to put property into that trust, you can. If you wanted to sell property that's in that trust, you can. Okay. So a revocable trust is really good for three different categories of people. And sometimes, I had a client today, they fell into all three. Sometimes people don't fall into any of them and they're fine with doing a will, but everybody needs at least a will. So the first type of client that needs to have a trust is anybody who wants to have control over their funds after they've passed away. Okay. Maybe you have millions of dollars and you can't leave that to your 25-year-old daughter. Maybe you have a child that's been battling with addiction issues, whether it be substance abuse, alcohol, other. Maybe you have a child that has had some financial issues. Maybe they're really successful and, market crashes and now they have to file for bankruptcy. Or maybe they're in a car accident and they have some liability that could come from that. So anybody who wants to have their money in a trust, that protects it from any of those, including divorce from a spouse, unless the money is taken out of the trust. So anybody who wants to have control of the funds where they can say who's to manage that money for the beneficiary and the terms surrounding when that beneficiary can get the money, they need a trust. The reason they need a trust is because otherwise all of those, you could do a testamentary trust, which is where you say the same thing in the terms of a trust, but that means we're not using beneficiaries for those assets. We're directing all of our assets to that trust, right? I have a 4-year-old. If I pass away, I want it to all go to my husband. And if both of us pass away, we want everything to go to our 4-year-old, okay? If I have all of that in my will, I can have a trust for her. And it says that when she turns 25, then, I start naming how much she can get at different ages of distribution. But that means all of my accounts, all of my money, in order for it to be subject to the terms of that trust, have to go through probate. That means my 401k, my bank account, my car, my house, everything's going through probate and subject to that 1.25%. That's fine for some people, but for some people it's not. Okay. So for the people that want to have a trust, generally that want to have some control over their funds and be able to set up a trust for a grandchild or a trust for their kid or a trust for even their spouse, we see that too, where they could protect the money and then provide for their spouse, but then provide for their children separately. A revocable trust is definitely the way to go. The second type of client who needs to have a trust is anybody who has property in more than one state. So if I pass away, I'm a resident of the state of Delaware, but I have property in California, New Jersey, Florida, you name it, any state, my executor is going to have to go through probate in every state in which I own property if I don't have a trust. That's because the law provides that every state in which you own real property, you have to go through at least an ancillary filing in that state. So if I have property in more than one state, that means that probate's just gotten more complicated for my executor. Not only are they trying to figure out where my assets are, they're now having to file in Delaware and they're having to file in other states too, which all have different processes because state law governs. So they all have different processes that they're going to have to figure out what they have to do in order to probate your estate and then distribute those assets. Also, surrounding states have different laws. Like I said, all estate planning and trust administration is all governed by state law. There are some federal law, like tax laws, that have implications in planning that we work on and that we're aware of, that are the underlying reasons that sometimes we do different things in your estate. But generally, I know New Jersey, Pennsylvania, those all have, and Maryland, those all have a whole different scheme than Delaware. Where if I have a property, a piece of real property in Maryland, that's going to be subject to more taxes than in Delaware. If it's in Pennsylvania, same thing. And all of those attorneys can charge whatever they personally charge for those, okay? In Delaware, if you're out-of-state resident and we're just doing an ancillary filing for a Delaware property, it's not a super big deal. But I know in other states it is. I have a conference call tomorrow for a piece of property that's in PA. The attorney wants to talk to us about it. So that tells me it's going to be more complicated than me saying, yep, just send me the documents and I can file something. Okay. So the third type of client is not the client who necessarily needs a trust, but they just decide that they want to avoid probate. Maybe they've been through probate. Maybe they've handled it for a loved one themselves, or they just say, you know what, I want it to be simple for my kids. My kids are living their own life. They have their own kids. They live in New Jersey or New York or wherever. I don't want them to worry. I don't want them to have to do all that filing with the Register of Wills. I want it to be easy for them. Those are the clients that also decide to do a trust, okay? I sit down with every client who comes into my office and we talk about what's going on with the kids. Do those kids have kids? Do we like the spouse? I'm kind of nosy, but it's important because it's important that I know the whole family dynamic of what's going on, what kind of assets you have, how, can we use beneficiary designations to transfer that asset to our loved ones, or do we need to have more control over that asset for any particular reasons? These are all, do I want to provide everything to my spouse? Do you like your sister-in-laws? Do you like your brother-in-laws? And all of that's important because we put in these documents, we want to make sure that we're carrying out what you want. You guys have been blessed with these assets. You've worked hard for these assets. You're a steward of these assets, and you want to make sure that they go to the people that you want them to go to. Okay. So that's the difference between a will and a revocable trust and intestate. Intestate, no will. Probate, you have a will. So intestate, the state says where your assets go and who your executor can be. With a will, you say where it goes. Both of those are subject to probate. And then a trust is a probate avoidance tool as long as we properly put all of our assets into the trust or have a beneficiary on it. Okay. So in the 40 minutes, I believe that I discussed everything that that I was asked to present on today. Are there any questions with regard to any of that?
What are your thoughts on registering your will before death?
Great question. So Newcastle County started the process they call, and I know other states do it. So some states require that you register it. In Delaware, it's only very recent that Sussex County has provided for the ability to register a will. In Newcastle County, they call it they call it in every county now, will for safekeeping. And I think that it's a really good option to have for everybody. The reason I think it's a good option to have is I have seen times when wills have become missing, okay? If you're doing an equal distribution to all 3 of your kids or to all 2 or to whoever, not a super big deal, okay? If everybody kind of knows where your documents are, I always recommend that you tell everybody where your documents are so that they know it exists. If you don't want to tell everybody where your documents are and you're not doing an equal distribution, if you're disinheriting somebody that would otherwise be entitled to receive through intestate law, then I think it's very important to register your will with the Register of Wills. And what that does, that process, you call and make an appointment. You personally have to take your will to the Register of Wills. They do not review it. They just take it. They see your ID. They confirm it's you. They have you seal it. They put it in a folder. Okay. They have documented all the wills that they have. But then if you pass away and somebody provides a death certificate, they have your will on file. So that way nobody can say, your will can't become missing. So Generally, I have my mother-in-law's will. My husband's going to be her executor, aka me, when she passes away. And again, he has the duty, but I have the I actually have the duties, but he's going to sign it. But everything goes equally to her kids. So we have no intentions of hiding a will. But if you're planning on disinheriting anybody, I think it's a nice option to have the option of being able to file it. Similar to that, if you do update your documents, I do recommend as a courtesy to reach out. And here we provide you your original and all of your copies. Most attorneys in Sussex County do follow that practice. Some law firms in other states will hold on to your original. I always recommend that if you do decide to amend your documents, your new documents make your old documents null and void, but as a courtesy to the attorney's office, you should notify them that you've amended that document. And so that way they can go ahead with your permission and get rid of their copy. So that way they don't have a vault of all of these documents, because they can't just shred them if they have that fiduciary duty to you. So as a courtesy, you should always let the prior firm know if they're holding your originals. I guess one last thing that I didn't talk about that came to mind through your question, Bill, thank you, is what documents do you need to have? So like I said, we do recommend that you keep your documents in a fireproof box inside your house. That could be a safe or something else that's fireproof that's inside your house, and that you tell your loved ones where they're located. If you decide to give copies to each of your kids, that's fine, that's your choice, but not all clients are comfortable doing that, okay? Because then if they change their mind, now they got to go back and tell people they changed their mind, right? Or maybe you're disinheriting a daughter and you don't want her to know yet, or maybe you say, that you hate your son-in-law, who knows, right? So we don't necessarily want them to have the documents sometimes. But in all cases, I always recommend that you let everybody know where they're located inside your house. Also, you need to have a list. What I generally recommend to all of my clients is that they keep one document from every bill or financial institution for any accounts that they have. That becomes very helpful, because I've had spouses in the past that they weren't even sure if they collected all of the assets, all life insurance money that their spouse may have had. And that's kind of hard, when they're young and they lose a spouse and they don't even know if there's assets out there that they're not collecting on. But also, if your kids aren't from Sussex County, Delaware, it's nice for them to be able to go wherever your will is and see if you had a plot prepaid, if you pre-planned your funeral, if you prepaid for your funeral, what life insurance policy, if they have a copy of all of the information, then they can say, oh, mom or dad, they had a life insurance policy with State Farm, and here's the policy number. I can call State Farm and I see how much the policy amount is. It streamlines everything. It also allows them to know who your mortgage company is, to know who your electric company is, to know who services your water. So that way they can very quickly get in there and start paying the bills. And if you keep all of these, if you do online paying or you do all of this online, you need to have a list with all of your passwords, what the account information is. I keep mine in my phone. So if anybody ever finds my phone, I keep mine in my phone secure. But that way I can go in, because, nowadays they make you change it all the time. So instead of having a list that's at my house, I keep mine in my phone. But if I were to pass away, my husband needs to know the password for my phone, because I pay all of our bills. And he would have no idea where to start, because we're not getting statements at the house. They turn off the electric, the water, the sewer, it's all done on them. So it's very important that we keep those documents for our loved ones. So we're just trying to make it as easy as we can for them, because they're doing us a favor. They want to do a good job. They want to carry out your wishes. And we're just trying to set them up for success, so that way they can have access to everything that they need. Because you got to remember, this is a time that they're grieving. I have never met anybody who comes into my office happy that they've lost somebody. And I see all ages. I always, when somebody comes in, they're like, oh, I should have done this a long time ago. I always joke and I say it's not too late. But I can tell you, I have widows in my office that they're not even entitled to really live in the house that they live in. And there's no money left to them because everything was left to the son. And these are people in their 30s. I have a client right now We're going through all kinds of issues. Everybody needs to have a will, because otherwise the spouse or girlfriend isn't necessarily entitled to what you want them to have. So I always just say a will keeps everything really easy, because oftentimes, I mean, I have an estate right now that there's an alleged sister that we don't even think is a sister. So, now we're going to go to court and have to argue whether this person is actually related. If he had a will, he would have provided for his kids, not for this alleged sister. So I mean, I see it all. And I think that a will, I always say, if they just had a will, all of this would be so much easier for their family, and it destroys families. But if you have a will, it makes everything easier. So with regard to going back to the online accounts, we put in our social media is big, and all of these social media, Facebook, I don't even know all of them. I'm not on any of them. But there have been times that people in California that do all of, made Facebook and made all of these things, that they pass away and nobody has access to go online and terminate their account. Okay. Delaware does have a law that provides that your executor is able to go on to any accounts that you have, like Facebook, and terminate that account. We put that in our wills, and we also put that in our durable power of attorney. Okay. Honestly, if you're not with us, it's a little creepy if you still have a Facebook page. Okay, so that's an important thing that Delaware does provide for, and Delaware's kind of on the cutting edge with having these laws in place for that. All right. Any other questions? I like questions. All right. Well, as we discussed earlier, I'm happy to help. I like getting out in the community, talking to people. I love estate planning. It's my passion. I get so excited to do it. Like I said, people feel like, I don't think people really think I'm being nosy, but I just like sitting down and meeting with people and going over and being helpful and providing all the information that you need so you can get a plan in place. I love what I do. This is my passion, and I'm happy to help. So if you guys have any questions, you can feel free to give me a call. Our office number is 302-645-2262. If you need your documents reviewed, Mike or Sarah, my paralegals, would be happy to schedule a time for you to meet with me. If you need new documents, like I said, it's not too late, but do it before it's too late. We can always make an appointment to talk about any issues that you guys have and to make sure that you guys are getting the assistance that you need. All right. So thank you guys. If there's no other questions, then I'll turn it back over to you.
Thanks, Rebecca. I really appreciate you taking the time, and our thanks to Heidi Gilmore, your coworker, who's a member of St. Peter's, who recommended you. Bill Martin's asking for your number again, so if you could just say it one more time.
It's 302-645-2262, and I put it in the chat.
So the great thing about this series is that it will be up on our YouTube and Facebook pages, so you can come back to this later. If you didn't write something down or you missed something, this will still be there for you to be able to look at. But as I said at the beginning, this is really one of our Christian responsibilities, is to be a good steward of the things that we've been blessed with, and to make sure that we make our wishes clear to our family. It comes right from our Book of Common Prayer on page 445, if you're wondering where that comes from. But we all have a responsibility to do our best by those who love us and will be around after we have left, to provide for them when we're able, to provide for the charities and the things that are important to us, including the church, and to make our wishes known and clear so that families at the deathbed are not struggling to figure out what to do, what care to provide, or even what the implications will be for them financially on the occasion of your death. So I'm grateful to Rebecca and for her coming on today to share with us. We are so fortunate to have a lot of good attorneys in our community like Rebecca, who are willing to work and help folks make their plans and help them do exactly what they want to do and what is right for them. So with that, I'll just say thank you all very much. It'll be up on Facebook. Thanks, Rebecca. Blessings to you in your work, and I hope you all have a wonderful day. Take care.
Thank you.